What happens to the cost basis when a parent dies owning property with a child? If a parent and a child own a property jointly and the parent passes away, the effect on the cost basis depends on the country. It could also change if the parent has a surviving spouse. I rarely see a situation where married parents purchase property jointly with their child. Joint ownership with parents and children almost always happens because the parent is doing estate planning on their own and they want to make sure the property goes to their only child or a specific child. So in the US, there is an estate tax and not a deemed disposition tax. Whether the property is a primary residence, second home, rental property, or any other type of asset, the child will receive a step up in the tax cost basis with no taxable capital gains. Instead, the value of the parent's estate is subject to estate tax. There will be no tax to pay if the value of the parent's estate is below the estate tax exemption for that year. I'm only talking about federal estate tax. Some states also have an estate tax that is not consistent with the federal exemption. If the parent paid for the entire property, the child's cost basis will be reset to the fair market value at the time of death. That could eliminate capital gains taxes for the child if the property is sold soon after. If the child paid for a portion of the property, their portion of the cost basis would remain the same, and the value of the parent's portion at the time of death would become part of the cost basis. If the child was added to the title but did not contribute proportionally to the purchase, any additional ownership that they received but did not pay for is a gift and may need to be reported to the IRS. If the amount was above the annual gifting exemption amount, the parent's estate tax exemption amount is decreased by the amount of the gift minus the gifting exemption for the year, which is $19,000 in 2025. The estate tax exemption for U.S. residents and citizens is $13.99 million in 2025 and will be $15 million per person in 2026 and indexed for inflation in the future. U.S. citizens get unlimited spousal portability, even if they do not live in the United States. Non-resident aliens who own U.S. property only receive a $60,000 estate tax exemption. The tax treatment at death is different than if the property is sold. The U.S. has a $250,000 primary residence exemption for individuals and $500,000 for married couples. The exemption applies if you have lived in the property for 2 of the past 5 years. Capital gains tax applies to sales, estate tax applies after a death. The mechanics of transfer and exposure to probate would differ depending on if the property is titled as joint tenants with rights of survivorship, tenants in common, or tenants in the entirety. In Canada, there's no step-up. Instead, there's a deemed disposition. The parent is considered to have sold their share at fair market value upon death, triggering capital gains tax in the estate if it is not their primary residence. Only then does the child get a new cost basis after tax is paid on the parent's final tax return. An exemption may be available if the parent has a surviving spouse, depending on the specific circumstances, or if they lived in the home the entire time they owned it. If the deceased parent lived in the home, Canada has an unlimited primary residence exemption, and the value of the parent's portion at the time of death would become part of the tax cost basis for the child. If the parent only lived in the home for a part of the period of their ownership, there is a prorated capital gains tax based on the period it was used as their primary residence versus the period of ownership. You can research that more on our blog. So while the U.S. approach may delay tax until the sale or exempt capital gains altogether during the parent's lifetime, Canada's system may trigger it immediately. That makes joint ownership and estate planning especially complex for cross-border families. If you're navigating this situation, speak to a tax advisor, financial planner, and estate planning attorney before adding a child to title or making any large gifts for estate planning purposes. At 49th Parallel Wealth Management, we are comprehensive financial planners that advise on all areas of financial planning and wealth management. We serve clients all over Canada and the US, and we can help you whether you're crossing the 49th parallel or not. Visit our blog at 49thparallelwealthmanagement.com to learn more about gifting and cross-border estate planning and much more. From the desert to the tundra, we are your cross-border retirement planning experts.